Good morning, or good afternoon rather, everyone. My name is Alex Lamont, and I am a Legislative and Policy Coordinator for the New York State Association of Counties. On behalf of our President, Jack Marin, and our Executive Director, Stephen Aquario, I want to thank you for joining us this afternoon for a virtual fall seminar workshop about meeting New York State's climate and renewable energy goals. Our 2020 virtual fall seminar is taking place through the end of September and includes nearly 20 workshops and meetings designed to bring the latest information on issues facing today's county government to county leaders. We thank you for joining us as we move counties forward together, and we encourage you to use hashtag #CountiesForwardTogether to tweet about what you're hearing throughout the conference. This afternoon, we're here to talk about the landmark Climate Act that commits New York State to the most ambitious greenhouse gas emission reduction and renewable energy targets in the nation. We'll also talk about legislation passed earlier this year that overhauled the siting process for large-scale renewable energy projects in New York State. This workshop will bring you up to speed on the state's bold climate actions and how they will affect your county government. We're joined this afternoon by two panelists. The first is Kara Allen, who is a Senior Advisor for Policy and Regulatory Affairs at the New York State Energy Research and Development Authority, or NYSERDA. Kara manages NYSERDA's implementation of the Climate Leadership and Community Protection Act and came to NYSERDA from Governor Cuomo's office, where she served as Assistant Secretary of Energy. Prior to moving to New York, Ms. Allen was the Executive Director of the Sustainable Energy and Environment Coalition, SEEC, a coalition of House members dedicated to advancing policies pertaining to clean energy, innovation, and job creation, environmental protection, and global climate change. We're also happy to be joined by Hutan Moveni, Executive Director of the New York State Office of Renewable Energy Siting. Hutan is a dedicated energy professional with over 15 years of experience in the energy sector and a track record of developing and implementing a wide range of clean energy initiatives. Mr. Moveni has held leadership roles in New York State's energy efforts since 2014. Prior to his current role, he was the Director of Facility Certification and Compliance at the New York State Department of Public Service, DPS, and he led the certification and compliance for all electric generation projects and all electric and natural gas transmission projects considered under Article 10 of the Public Service Law. Before we begin, I'd like to thank our sponsor, the John W. Danforth Company, for sponsoring this session. As a one-stop building solutions provider, Danforth provides strategically integrated services that allow their team to take a comprehensive view of their customers' facilities and offer the very best in custom-tailored solutions. Their focus areas include HVAC systems, lighting, air filtration, plumbing systems, project development, design build, energy solutions, performance contracting, and preventive maintenance for county government markets. Additionally, their team can provide county governments with potential procurement financing operations through mechanisms such as Gordian, National Grid, and NYPA. With that, I'd like to turn it over to our first panelist. Kara, thank you so much for joining us this morning.
Thank you, Alex, and I want to say thank you to NYSEC for the opportunity to speak to all of you this afternoon. This is a very important topic. I'm very glad to be here and to know that all of you are keenly interested in this act. So with that, if we could go next slide, please. Great. So I'm going to begin talking about the Climate Leadership and Community Protection Act, or the CLCPA, by giving a brief overview, making sure that we're all on the same page about what the act is and what it does and how it came to be. So next slide, please. The Climate Leadership and Community Protection Act, or CLCPI, was passed through the New York State Legislature last year and signed into law by the governor in July. It became effective January 1, 2020. And the kind of headline provisions of this legislation I would characterize in two buckets. One would be climate leadership and the other community protection. And you can see a lot of the climate leadership provisions spelled out here, which are notably a number of different targets for greenhouse gas reduction, renewable electricity consumption, and energy efficiency. So the notable headline is the one right up at the top, that we are seeking to advance a carbon neutral economy, requiring that at least a reduction of at least 85% in greenhouse gas emissions below 1990 levels by 2050. The 40% reduction below that is a bit of a known commodity. It was something that was first put forward in the state's energy plan in 2015 and was applicable to the energy sector. The governor expanded that to be economy-wide via EO 166, and now this legislation has put that into law. Also notable, for the renewable electricity side, the 100% zero carbon electricity by 2040. This is a nation-leading target. Many of these targets are nation-leading, but this is certainly top of the list here, and again, something that we've been working toward for some time and are very excited to have this serving as the backbone to achieving the 85% reduction by 2050. As sub-targets to that 100% goal, we have a 70% renewable electricity goal by 2030. This builds on the Clean Energy Standard goal of 50% renewable electricity by 2030, so we've increased that goal. And to help support that renewable electricity goal, we are looking to have installed 9,000 megawatts of offshore wind by 2035, 6,000 megawatts of distributed solar by 2025, again, expanding the goal of the New York Sun program, which Bhutan also worked on for some time while he was with us at NYSERDA, and then the 3,000 megawatt energy storage goal by 2030. In addition, the energy efficiency goal that was put forward under the New Efficiency New York process, which has been ongoing for a couple of years now, that goal of 185 trillion BTUs of on-site energy savings by 2025 is also now codified into law. And in addition, and the last point here speaks to the community protection aspect, there are a number of commitments to climate justice, just transition, and environmental justice that are throughout the law, the most notable of which have to do with investing to benefit disadvantaged communities. So at least 35% of clean energy and energy efficiency investments must go toward, the benefits of these investments must go toward disadvantaged communities in the state. Next slide, please. So there's a lot to get us moving forward and a lot of different groups that have been created to help with this work. Most notably, the Climate Action Council. The Climate Action Council is a 22-member body that was constituted at the beginning of this year. So the governor had 2 appointments. The legislature had 8 in total, 3 coming from the Assembly majority, 1 coming from the Assembly minority, 3 coming from the Senate majority, and then 1 coming from the Senate minority, in addition to state agencies that were identified in the law. So those council members were named at the beginning of the year. The Climate Action Council met most recently in August, and they are focused on, as it says here, preparing a scoping plan for how we will achieve the greenhouse gas reductions in the law and ultimately move the state's economy toward carbon neutrality. The Climate Justice Working Group, I mentioned earlier that we are looking to provide at least 35% with a goal of 40% of our clean energy and energy efficiency investment benefits to disadvantaged communities. The disadvantaged communities will be identified by the Climate Justice Working Group. They will come up with criteria that will serve to identify those communities and then develop a list of who the disadvantaged communities in New York are. Then the Just Transition Working Group, this is a group that will report into the Climate Action Council alongside the 6 sectorally focused advisory panels. The Just Transition Working Group, though, is focused on an economy-wide scale and is looking at job creation and workforce disruption, also workforce opportunity. So that group will be helping the Climate Action Council in preparing their scoping plan, along with the advisory panels, which I'll speak to more in a moment. The Public Service Commission is, and folks may be aware, is actively moving forward with a proceeding to implement the 70 by 30 goal for renewable electricity, and we'll be moving forward to do the same on the 100 by 40 target. DEC is a key partner in all of this. I am here representing NYSERDA, but we are working hand in glove with DEC on a number of these tasks. DEC ultimately will have the task of taking the scoping plan and promulgating regulations to ensure these greenhouse gas limits are met and accounting for the direction of the scoping plan in thinking about the regulations that they pursue. DEC is also moving ahead to establish a value of carbon for use by New York State agencies. They are also actively working in collaboration with NYSERDA to come up with a new accounting methodology for how we are tracking the state's greenhouse gas emissions. There were some changes in the law around how we do our greenhouse gas accounting, so DEC is also working on that. And again, they are promulgating regulations to implement the scoping plan. And then across all of our agencies, this is not something that is just taking place within DEC or NYSERDA or even just the agencies named to the Climate Action Council. This is an all-agency hands-on deck process where we are looking across each of our operations to think about how we can be reducing our greenhouse gas emissions and considering how we can be consistent with the act in our agency decision-making processes. Next slide, please. Thank you. So what I just laid out is, or what I just discussed rather, is laid out on this timeline. So you can see here that this is a multi-year process. There will be work by the Climate Action Council, as I mentioned. There will be work by state agencies, as I mentioned. So you can see that spelled out here. What I will call attention to is the scoping plan process in particular. The scoping plan will be, a draft of this scoping plan must be released by January 1, 2022. So all of the efforts that are currently underway are with that target in mind. The draft will be released. We will hold no less than 6 public hearings on the draft scoping plan across the state, and all of that with the intention of pulling together a final scoping plan for approval by the Climate Action Council by January 1, 2023. Next slide, please. So to take a moment on the Climate Action Council, I mentioned a little bit about them earlier, but these are the members of the New York State Climate Action Council. So again, I mentioned before that we have a number of state agencies named. You can see those in kind of the lighter shade of blue. The Climate Action Council is co-chaired by Dorian Harris, the acting president and CEO of NYSERDA, and Commissioner Basil Segos of the Department of Environmental Conservation. And then again, the rest of the agency folks in the light blue and the appointed members in kind of that darker shade of blue. This is information that is also available on our website, climate.ny.gov. That website address will be shown in a later slide as well. Next slide, please. Okay, so now we'll take a moment to talk about the Climate Action Council's advisory panels and the Just Transition Working Group, which I mentioned briefly earlier. Next slide. So there are 6 sectorally focused advisory panels. These are advisory panels that were named in the law. So those are transportation, agriculture and forestry, land use and local government, power generation, housing and energy efficiency, energy-intensive and trade-exposed industries. Those are the 6 advisory panels. They are each chaired by a Climate Action Council commissioner or designee. In most cases, it is, in fact, the commissioner chairing the advisory panel. And as I mentioned earlier, the Climate Action Council is tasked with developing this scoping plan for how we can achieve the state's greenhouse gas reduction. These advisory panels play a critical role in that they will be providing the council with a series of recommendations for how, within their sector, we can go about achieving those reductions. The Just Transition Working Group, as I mentioned earlier, is another group that will be serving to provide the council with recommendations. They are a little unique in nature because, as I mentioned earlier, they are focused economy-wide, and we'll be looking at, again, the workforce implications associated with decarbonization, tasked with a study to look at the number of jobs that will be created in our efforts to counter climate change, the skills and training necessary for those jobs, and then also workforce disruption, and trying to see how we may leverage the skills of our existing workforce for this clean energy future. They will also be looking at opportunities for us to reuse certain power plant sites. So the group will be producing an inventory of potential power plants that could be closing as a result of our decarbonization efforts, and looking at opportunities to reuse those sites, not necessarily strictly in a clean energy context, but really opportunities across the board for how we can reuse our power plant sites. And as I mentioned earlier, the Climate Justice Working Group is tasked with identifying those disadvantaged communities. They held their first meeting on August 14th, and we expect there will be another meeting of that working group soon. Next slide, please. So this lengthy slide provides a little more detail here on what the advisory panels will actually be producing. As I mentioned earlier, their core task is advising the council on how we can achieve our greenhouse gas reduction. So part of that process will include, as you can see here, this is in the sub-bullet to bullet number 2, identifying estimated scale of impact of their proposed strategy, the cost to achieve that strategy, considering if there's if it's a technology, if it's commercially available, or how we can make it deployed, and then the co-benefits associated with the emissions reduction strategy. Central to all of the recommendations, we need to be thinking about how we're advancing climate justice outcomes and how we are impacting our businesses. So these recommendations may have quantitative analysis associated with them, or may have a qualitative assessment associated with them, but as you're seeing here, there are several core features that need to be accounted for in these recommendations. As I mentioned earlier, they should be sector-based. The panels are not going to rely on economy-wide policies, but can recommend that the council consider economy-wide policies if those policies are needed to advance certain sector-specific outcomes. Now, you might be wondering, and this is certainly true of a number of panels where you can see that they will have kind of overlap or potential topics of mutual interest. In the case of mutually, in the case of recommendations that may cross sectors, we are encouraging the advisory panels to go ahead and identify those potential areas of mutual interest and be sure to consult with one another as they advance recommendations that may cross over into other groups' scopes of work. Finally, and this is something I know near and dear to a number of your hearts, we also want to make sure that the recommendations are thinking not just about mitigation, but also about how we will adapt to our future under various climate scenarios and bolster our resiliency. So each of the panels will be thinking about that. They will ultimately make recommendations to the Land Use and Local Government Committee, advisory panel, and that group will ultimately have the task of putting forward a collective suite of adaptation and resilience considerations for the Climate Action Council to consider in the scoping plan. Next slide, please. So this is more on the kind of process and cadence here. The advisory panels will be meeting at least once a month. We expect they will provide regular updates to the Climate Action Council. Some of those may come in actual oral updates. Some may actually be written updates to the council. But again, the purpose here is these advisory panels are providing the council with their advice. And so it's ultimately up to the Climate Action Council to make decisions about which recommendations will proceed in the scoping plan. So we want to ensure there are regular touch bases throughout the process so that the council is aware of what's happening within the advisory panels and is able to provide them with guidance. The advisory panels will each consult with the Climate Justice Working Group. Again, part of their charge is to be thinking about climate justice and how their recommendations will advance climate justice outcomes. They also need to meet with the Just Transition Working Group, because the Just Transition Working Group, as I've said now a few times, is charged at looking economy-wide. So each of the groups needs to meet with them in addition to consulting amongst their membership. There will be opportunity. I want to underscore this. There will be opportunity for public input. We are going to require, and this is a minimum, at least one forum where they can receive broad-based public input. That will not be the only opportunity through which input can be received. We expect to be building out our website so that you can find information on each of the advisory panels, including ways to provide your thoughts and comments throughout the process. You'll see that hopefully rolling out soon, but again, we'll have opportunity for you and others across the state to provide your thoughts at any point during this process. We are also encouraging the meetings to be public as often as they can be, and that is something that each of the advisory panels will be thinking about as they develop work plans to guide their process. Each of the advisory panels that has met so far has done so publicly, and we expect those that are, well, not we expect, the two that are happening tomorrow. I will note that energy intensive and trade exposed industries and land use and local government will be meeting tomorrow. Both of those two meetings are open to the public, and information on the meetings is available on the climate.ny.gov website. Next slide, please. Land use and local government. I imagine this panel is of particular interest to folks participating today, so I wanted to take a moment to share with all of you who is on that panel. As you can see here, Sarah Crowell of the Department of State will be chairing the panel. She will be assisted ably by Mark Lowry of the Office of Climate Change at the Department of Environmental Conservation. And then you have a number of different folks from across the state who will also be participating in this panel's discussions. And as I said, the first panel meeting will be taking place tomorrow. Next slide, please. What will the Land Use and Local Government Advisory Panel be looking at? So this is this is a kind of starting point that was provided to them by the council, and we expect that that panel will continue to build on this in their conversations about their scope of work and their work plan. Some of that I would fully expect to take place during tomorrow's meeting. But to start, they will be looking to consider local perspective and providing local perspective to the other advisory panels. So again, working in a very collaborative nature with the other panels and aligning their land use strategies and local government policies, how we can align our land use strategies and local government policies to ensure fulfillment of some of the strategies that these sector-focused panels will be considering. Some of the strategies to go about doing that, you know, everybody's always a fan of a good plan. So, you know, thinking about ways that we can help support all of you in your local planning efforts to account for these policies, thinking about housing policies, zoning, transit-oriented development, green spaces, stretch codes. So really, you're where the rubber meets the road here, and we know that. And so this is where, again, I think this panel has a very key voice to making sure that the things that are coming forward from the other groups are considering what it means to actually move these policies forward on the ground. So this group will be providing that advice, that consultation to the other panels, and really taking what they're thinking about and saying how we will move that forward at the local level, ensuring that we have education and capacity building, that we are looking at things like community distributed generation options, community choice aggregation, stretch codes. Again, there's quite a list, but these are some things to start and where we think that this panel has very critical advice to ensuring success of our outcomes. There are going to be a number of opportunities where this panel will need to collaborate: transportation, energy efficiency, and housing, This is not a comprehensive list, I can tell you right now. I think the Just Transition Working Group, which Doreen Harris co-chairs, along with the Commissioner of the Department of Labor, Roberta Reardon, that Just Transition Working Group will also have conversations that will need the input and advice of the local government and land use panel. So again, this panel really also kind of serves in a very cross-functional way and certainly on very key topics. So next slide, please. This is a lot, obviously, a lot to take on from state agencies, which are already very busy working away to help mitigate the impacts of COVID and to handle our economic situation that we're facing here as a state. So we do want to ensure that they are supported in this effort moving forward, and that the advisory panels are also supported in their efforts, given that this is in a voluntary capacity. So there is some consulting support through a firm that has been doing research on various options for advancing decarbonization across the state. An analysis that they produced and actually shared with the Climate Action Council is available on our website. There will also be working groups of state agency staff who will be supporting these advisory panels, a number of various studies and other research resources. And if it makes sense to have more of that kind of research conducted, there can be additional research done, sort of light research done by the state agency staff. And then also there will be some facilitation services. We'll anticipate that they'll be helping us to schedule these meetings, keep records, et cetera, as you can see here. Next slide. So the next steps for these advisory panels, as I mentioned earlier, they've been meeting. A number of them have been meeting, and in fact, the final suite of meetings will be tomorrow. Each of the advisory panels will have held a first meeting, and they are focused on a work plan. So as I've mentioned the work plan before, what does that really entail? The work plan will build upon these initial directions from the Climate Action Council. So I showed you that earlier slide. That was, again, direction from the council. So the panel will be looking at that, taking that into account, and thinking more about that in developing their scope of work and identifying the topics and issues for the panel discussion. And again, any needed research to help further support those discussions. They'll also have a timeline for how they're going to go about doing their work and identifying points in their process where they will be seeking feedback from the public, where they'll hold that public engagement forum. And again, we've encouraged them, the meetings of these advisory panels themselves, to be public as much as the panels feel that they can make them public. And then in addition to sort of this timeline of meetings and public engagement opportunities, the timeline should also note other milestones that may, other processes that are happening that may inform the development of their recommendations. Next slide, please. This is the timeline as was introduced during the last Climate Action Council meeting. So you can see here, this is really, we're really in kind of this recommendations development and outreach phase at the kind of beginning stages of this. This is going to carry forward through about the end of March. And so there's a lot of work to be done over the next 6 months to bring these recommendations forward, and then ultimately to do some analysis. So again, the panels will have been considering things like benefits, co-benefits, costs, but we'll also have analysis that will take place to help further our understanding of what these mitigation strategies will really mean. That analysis will be brought forward as part of this draft integrated strategy to the Climate Action Council. So again, that they have that information and can make even more informed recommendations for the scoping plan, which, as I mentioned earlier, will have to be issued by the beginning of 2022. Next slide, please. So finally, I've mentioned it a couple of times. I can't stress it enough. We do have a website where we are keeping all of this information. So the Climate Action Council members that I mentioned earlier, members of our advisory panels, the schedules of their meetings, it's all available on this website. And like I said, the website will be expanding to allow for opportunities to receive public input, not just through these fora that will be held, but also to continuously take feedback. And I should say that, again, to the interest of all of you, we would anticipate that there will be outreach to local government, to local elected officials as part of this process. That is something, again, it is absolutely critical. We know you are key partners. You know how things happen on the ground. And so we expect that that will be something that the Land Use and Local Government Panel will be doing in their work. And again, you'll see more on their work during tomorrow's meeting and in future meetings as well. So with that, I'll conclude my portion of the presentation. Thank you all so much for your time and attention and interest.
Thank you so much, Kara. That was Kara Allen, Senior Advisor for Policy and Regulatory Affairs at NYSERDA. Just as a reminder, if you have questions during the presentation, please type them into the question panel on your webinar dashboard, and we'll take them up after the speakers finish their presentations. Typically, we do save all these questions until the end, but I want to make sure we get one in just before we turn it over to Hutan Mulvaney. We've received this question several times already in the couple minutes that we've been doing this webinar, and so I want to be sure you have a minute to expand on this. How exactly should interested county officials get involved with the Land Use and Local Government Advisory Panels if they're interested in being proactive about this? Where can they submit their feedback? Is there a contact you recommend? And a second question we've received a couple times already is how can a county representative be added to the panel?
All excellent questions. I will tell you that right now we don't yet have, I think, the infrastructure in place to take in the comments as much as we would like. That's not to say that you shouldn't go ahead and pull some feedback together for us. We do value that feedback. We value that feedback early. So just you can send that to me. As I mentioned, Sarah Crowell is leading this advisory panel, but we will have a website stood up with an actual contact, hopefully a form too, so it's a little more, it's easier to have the staff digest the input that they're getting. We hope to have that stood up very soon. So I cautiously offer my email address and Sarah as points of contact for now, with the note that there is more to come to really make sure that we are taking in as much comment as people want to be giving us. So for the time being, you could email myself, you could email Sarah. There is also an email address that we have on the Climate Act website that leads to DEC. So DEC is also taking, and we have gotten comments through that inbox. They are taking all of that for now and trying to make sure that we have that available to the advisory panels. So there are a couple of options, but they're very much interim options, I will say. And so please do look for more to come. I should have said you can sign up for updates. And so please do go to the website. You'll find a place where you can sign up to get updates on what's happening with this process. And so if you go there, you'll be kept in the loop about things like the stakeholder sessions, opportunities for comment, and the like. So I would encourage folks to do that as well. But in the meantime, you can feel free to use those email addresses, and you can use those email addresses to communicate suggestions on these panels. These panels are not static, and so we are always happy to take suggestions on the makeup. The advisory panels were approved by the Climate Action Council, and so any additions to the advisory panels will have to go through the Climate Action Council for their feedback. And so we are also looking to make sure that if there are voices that we know need to be part of this discussion that may not be fully represented on these panels, that we are having those types of discussions throughout this process. And so, as I mentioned earlier, we know that we need to be hearing from local elected officials. So the Local Government and Land Use Panel will be looking to meet with all of you to ensure that your comments, your feedback and direction is heard in this process. So you can expect that from them. That is a commitment I am confident to be able to share with all of you today. But again, if there are other names that you would like to suggest, you can put those forward, and I just make the note that this is ultimately, the panel compositions are ultimately a decision of the Climate Action Council.
Thank you very much. Again, you can continue to submit your questions through the GoToWebinar dashboard. We'll save the rest of them until the end. At this time, I'd like to turn it over to Hutan Mulvaney, who is the Deputy Executive Director of the New York State Office of Renewable Energy Siting. Thank you for joining us, Hutan.
Thanks, Alex. Good afternoon, everyone. I hope you are all well and staying safe. Before I begin, I want to give a great deal of thanks to New York State Association of County for their leadership, and specifically Alex and Katie for making this event happen. By way of introduction, my name is Hutan Mulvaney, and I am serving as the Deputy Executive Director for the new Office of New York State Renewable Energy Siting. Probably some of you may recognize me from my name, either from my accent, that as I had the opportunity to travel across the state, literally from South Shore of Long Island to the Canadian border, almost on a weekly basis for, I don't know, 4 or 5 years. So I had the opportunity to work with some of you in the past. Today, I will be providing you with a quick overview of the new act, but specifically new siting office. I will walk you through the decision-making process, and I will highlight some of the key areas. I'm going to go through a lot of information, and as much as time we have, hit on a lot of different points, but please take this meeting and this webinar nothing just more than a quick introduction. I'm here to serve you, and I will be happy to work with you one-on-one on all aspects of the new office. So if I'm not mistaken, my contact information should be available on the last slide. So please feel free to reach out to me. Katie, can you please go to the next slide? Thank you. Kara Allen did a great presentation and went over the CLCPA, which essentially provides a blueprint for achieving a zero-emission electricity production system in New York State. But specifically, I want to talk about a new act that New York State enacted on April 3rd of this year, known as the Accelerated Renewable Energy Growth and Community Benefit Act. For simplicity, I just summarize it and just call it the new act for the remaining part of this meeting. The main objective of this new act is to improve the regulatory review for the siting and construction of major renewable energy facilities and the transmission infrastructure necessary to meet the CLCPA targets in an environmentally responsible and cost-effective manner. Katie, can you go to the next slide, please? I'm not going to spend a lot of time talking about the new act, but just really high level, I wanted to quickly highlight 3 main elements of the new act. First, the act created the Office of Renewable Energy Siting, or ORES, to, as I mentioned, to streamline and expedite the permitting process for major renewable energy facilities. And that's the main topic of discussion today, and I'll get to that in remaining part of this presentation. Second, the Act provides NYSERDA with authority to acquire or lease sites and make those sites shovel-ready for building renewable energy projects. And finally, the third element of the Act was amending Public Service Law Article 7 and try to expedite the permitting of major transmission facilities in some cases to a 12-month time frame, and if basically for projects that they will be built within existing right-of-ways, reducing that time frame to 9 months. So can you go to the next slide, please? So as I said, again, today, primarily, I'm going to talk about the Office of Renewable Energy siting as the one of the key components of the new act. State of New York created the first in the nation Office of Renewable Energy siting to improve and streamline the process of permitting and siting large-scale renewable energy projects. The office will coordinate and undertake environmental review and permitting of major renewable energy facilities, and the office will have the authority to issue a single permit for the construction of these renewable energy projects. Under the new law, major renewable energy facilities are defined as renewable energy projects with a nameplate generating capacity of 25 megawatts or more. This project can be a hybrid system, meaning co-located with battery energy storage system. And the length of the transmission line for this project has to be less than 10 miles in length. If it's longer than that, the project, in addition to the permit for the renewable energy facility, must obtain certification under the Article 7 Public Service Law. Moving forward, as I mentioned, all renewable energy projects must obtain a permit through the new process and through the new office. However, renewable energy projects already in the initial phases of current Public Service Law Article 10 siting process may remain in the Article 10, or they can essentially opt in to the new permitting process. So the permit to be issued by the office essentially will include all necessary approvals from both state and local perspective. Once the permit is issued, Department of Public Service, or DPS, will be responsible for compliance and enforcement of the permit conditions. So specifically within this statute, the Act requires the Office of Renewable Energy siting to establish comprehensive regulations and a set of something known as uniform standards and conditions for major renewable energy projects within 1 year of the effective date of the statute. So basically by April 3rd, 2021. And if you go to the next slide, I'm happy to report that the office published the draft regulations and the uniform standards and conditions last week. Just again, spending some time going over the information that you can find on which are available on the ORA's website, and you can see it on the screen. The proposed regulations are in two packages or two parts. The first package essentially would be regarding application requirement, certain details about the process, the new process, and a series of other procedural details. And then the second package essentially would be the uniform standards and conditions, as I just recently mentioned, for solar and land-based projects. So before final adoption of the uniform standards and conditions, the office will be holding 5 public hearings across the state, as well as 2 virtual public hearings. Please reach out to me, or go to the ORA's website, as you can see on the slide, to find the actual specific event information. Although there are, I'm here to serve you and answer any question that you might have, but really from our perspective, these public hearings would be a formal opportunity for our local governments and stakeholders to provide input on the proposed uniform standards and conditions. Can you go back to the previous slide, if you don't mind? Thank you. So all stakeholders and public will have an opportunity to submit comments on the first package, the procedural regulations, until November 16, 2020, and on the draft uniform standards and conditions until December 6th, 2020. Really quickly, I want to give you an overview of the siting process, but specifically the two regulatory packages that I just mentioned. When we designed the regulations, we were trying to create a process that would be one-stop procedure with increased certainty and predictability to develop renewable energy project in New York State. And our approach was we were trying to proactively address some of the key recurring issues in the siting and permitting this large-scale renewable energy projects. Certainly, the new regulations will provide greater certainty over the content of an application and a comprehensive set of protections for some of the major siting concerns, things like noise setback, visibility, decommissioning, public health, and safety. But just really quickly to go over the two packages. The first package, as I mentioned, will specify application content, pre-application requirements, the type of notices that will need to be provided within the various step of the process, and also requirements for intervenor funding among other procedural requirements. The structure of the new siting process and the actual application includes 25 exhibits addressing various technical, legal, and policy-related issues. I'll talk about the uniform standards and conditions right now, but really the intent of the application process is to drive applicants toward compliance with this set of uniform standards and conditions. And to just give you really quickly a flavor of the uniform standards and conditions and how these conditions are intended to work, essentially, the best way I can describe them, you should look at these uniforms and standards and conditions to function as a menu of generic conditions or model permit conditions that will apply to land-based wind and solar facilities. The uniform standards and conditions the intent was to limit the need for site-specific conditions and minimize the need to negotiate issues that are common to the majority of these renewable energy projects. And really, the purpose was, as much as we can, try to guide project developers, applicants to design and avoid and minimize major siting impacts at the first place. And that's, I think, as you will see the regs, there are more details within that. And then if that's not possible, which in New York State, sometimes when you have a project, you have a competing, if you will, impact from environmental, like from agricultural impact, wetland, streams, type of T&E species, to public health and safety, noise, and beyond. So it's just finding those, if you will, balance among the boundaries of a property. But if that's not possible, essentially in the proposed uniform standards and conditions, we wanted to provide mitigation options to address some of those unavoidable impacts. So for those of you who have worked on some of these larger scale projects, you know that there is no such thing as like one size fit all, and I do not expect that the uniform standards and conditions can address every impact for every project. Like for example, visual and traffic impacts, that's something that require development of site-specific conditions, and that's something that we, as you can see in the regs, we are expecting close coordination between the office, applicant, and our municipalities and local government with respect to, like for example, like traffic issues. So, but all in all, if I have to just summarize, is like the under the new process that we call like 94C, the permit under the 94C will be a mixture of these uniform standards and conditions, along with some specific site conditions. In other words, like the uniform standards and conditions will be supplemented by tailored condition as needed to address site specific impacts. Katie, can you please go to the next slide? Perfect. So in the remaining time, I'm trying to go as fast as I can. I don't know how much time we have left. Just to give you an overview of the permitting process, I would like to walk you through the decision making in a little bit more details. This slide shows absolutely like a simplified flowchart of the application process, beginning with the date of receiving an application. And of course, this is just for the purpose of simplicity that this flowchart begins at the time when an application is filed. What's not shown here, as you can see in the proposed regulations, there are certain requirements and there are certain steps that must happen before an application is filed. Probably one of the most important one is the proposed regulations will require project applicants to consult with local governments and community members before filing an application, and also making sure that the application materials are available in both electronic and paper format. To just emphasize on that, like no application will be deemed complete without proof of consultation with the municipalities where the project is proposed to be located. Very quickly, to just touch on a few other pre-application requirements that, as you can see, we have outlined in the proposed regulations. The applicant would be required to consult with the office in consultation with other resource agencies, for example, New York State DEC, prior to submitting an application. And this is really to identify some of the site-specific environmental impacts that should be, I think from our perspective, should be avoided to the extent possible. And also, I think we wanted to get into, in addition to wetlands and streams, we want to look at the identification of any occupied habitat as well as any potential historical or archaeological issue at the site. So really the focus here is like, if you are familiar with the project development processes, we are trying to, like the first step usually is to site a project. So we are trying to, as much as we can, try to site a project in a environmentally responsible location in consultation with our local governments, communities, and also our sister agencies. And then the next step after working together and hopefully site a project in a responsible manner would be have the requirement for the application, certain design standards, and beyond that, as we have outlined in the application. And really the intent of, as I mentioned, the application is, as much as we can, we would like the applicant to illustrate how they can comply with the design standard as well as the uniform standards and conditions that we have provided. So the law explicitly recognizes that this renewable energy project must be cited in a timely and cost-effective manner, and specifically the office must issue a final decision on a permit within 1 year of the date of completeness determination for an application. In the case that if the project is proposed to be located on a brownfield commercial landfill, former power plant, or generally speaking, any abandoned or underutilized site, this deadline essentially will be reduced to 6 months. As you can see on the screen, 60 days is not very long time for some of the steps that we have in this process. But we have 60 days after receiving an application to make a determination if an application is complete. I can get into what really from the office perspective, what the completeness mean, what, like, in the interest of time, I'm just gonna skip over that. So after the 60 days, as I just mentioned, that office has to issue a completeness determination. Immediately after that, the office, in consultation with other resource agencies, must publish a draft permit. During the same time, the office must also provide a written notice of availability of the draft permit to the host municipalities. The statute requires that this notice must be done in a newspaper or electronic format, and also posted on the ORA's website. Again, as you recall earlier, the reason I spent some time going over the structure of the ORA's regulations, and specifically the uniform standards and conditions, because I believe that having the uniform standards and condition not only will help applicants to cite and design better projects, but also I believe that this would help the office to review these applications and issue draft permits in a more efficiently. And that's basically the idea behind having this uniform standards and condition. So once a draft permit is issued, there is a mandatory 60-day comment period on the draft permit. The public comment period is an opportunity for public to weigh in. The law specifically provides an opportunity for the host municipalities to advise the office with respect to the project compliance with local laws. So within the same 60-day comment period, the host municipality essentially must submit a statement indicating whether the proposed project is compliant with the applicable local laws. And this is very important because the office under the statute has the authority not to apply a local law in whole or in part if determines that such law is unreasonably burdensome in the view of the CLCPA targets and the environmental benefits of the proposed facility. So after the comment period is essentially closed, there is an opportunity for parties to reflect on comments, and then office must make a decision whether an evidentiary hearing will be held. This decision will be made with the assistance of an administrative law judge, and the Act specifies that an evidentiary hearing will be held if a significant and substantive issue requiring evidentiary hearing is identified throughout the public comment. And as you can imagine, there will be two steps in this process. So if the comments raise a significant and substantive issue on the draft permit, then the office will set an evidentiary hearing to hear the argument and the considered evidence. And following the close of that evidentiary hearing, the office will have to issue a final hearing report and any recommended changes. On the other end, if an evidentiary hearing is not required, meaning that there was no significant or substantive issue raised during the public comment, then the office is required to publish a written summary and also an assessment of public comments explaining why a specific issue that was raised during the public comment has not been addressed by the office. And again, as I mentioned, the overall process is within 1 year or 6 months. Can you go to the next slide, please? I'll try to be very quick on this slide, but I know it's important, and I'm interested in getting into the QA section. So as basically one of the feature of that was retained in the new law that carried over from Article 10 is the availability of intervenor funds. Very similar to Article 10, Section 94C requires applicants to make funds available to facilitate local government and public input. Each applicant will need to pay $1,000 a megawatt of facility generation capacity into a local agency account that will be established by NYSERDA. As I mentioned, this intervenor funding should be used by local governments and community members who wish to be engaged in the public comment process, as well as the hearing process. And specifically, as I mentioned on the previous slide, during the 60-day comment period, the host municipalities must submit a statement to the office indicating whether a proposed facility complies with local laws. So this fund will be available to help our local governments to hire any legal or technical support or any consultant to help them essentially determine whether the proposed facility is in compliance with local law. Something else is just like, given that the time limits that required in the statute, we require that it would be important for local governments and communities to get this fund as quickly as possible. So as you can see in the regs, we try to provide a certain notices across the board during the pre-application and after, to make sure that we make this fund available as soon as possible for our local governments. I think I'm a little bit over my time, but let me stop here and ask maybe Alex, you want to go over the questions?
Yes, thank you very much, Mr. Mulvaney. Kara, if you're still with us, I want to give you one more question before you have to tend to your other obligation. We've received a couple questions. Yeah, thank you very much. We've received a couple questions about our agricultural communities, in particular, what the state strategy for avoiding of food versus energy conflict in land use is. The question continues that our prime soils are at risk with energy projects that are greater than 6,000 in one county. There's a real concern and that this will change the landscape of New York and maybe hinder our ability to feed our communities and people. Another attendee asked if Ag and Markets is going to be involved in any of the panels to provide input and minimize some of these impacts on farm loss and the loss of food producing land.
So I guess a couple of things in response to that. Thank you for the question, and this is something that the state has been very mindful of. I know Hutan can actually speak to this based on his prior experiences working with NYSERDA about how we try to make sure that there is not a conflict between food and energy production. But I can say to the question about the involvement of Ag and Markets does chair the Agriculture and Forestry panel. In fact, most agencies, not NYSERDA or DEC, chair the advisory panel. So I'll briefly just say for Agriculture and Forestry, that is Commissioner Ball. For Transportation, that is Commissioner Dominguez. For Land Use and Local Government, we've talked about Sarah's role in the Department of State. For the Energy Efficiency and Housing Working Group, that is chaired by Commissioner Ruth Ann Bisnoffit of HCR. And for Power Generation, the chair of that panel is John Rhodes. So each of the panels, we've been very mindful to ensure that the chair of that panel is somebody who has the kind of foremost thinking about what is happening within that particular space. And they're obviously supported by a number of other state agencies, DEC and NYSERDA among them. But you can rest assured Ag and Markets is part of the discussion with respect to the Agriculture and Forestry panel. And I should also point out Commissioner Ball is a member of the Climate Action Council as well. So again, the full suite of membership to the Climate Action Council and these advisory panels can be found on our website. And these types of discussions will be very important to the advisory panel. But as I mentioned earlier, I know that this is not the tension, the tension between food and between energy is not something new to us and something that we have been thinking about and trying to act upon for some time. And like I said, I know Hutan has experience in this previously.
Thank you very much. Kara has to leave us for a prior obligation, but you can reach her at kara.allen@nyserda.ny.gov, that email address on the screen there. Hutan, if you're able to stick around, we have a number of questions for you from our attendees.
Absolutely, I'm here.
Thank you all very much.
Thank you.
Thanks, Kara.
The first question, with respect to ORAs, most county governments or local governments meet once per month. What is the most efficient way to interact with ORAs during the application review process?
So a couple of things I think from our perspective. One is in the proposed regulations, there is a mandatory requirement that, as I mentioned, the applicant must notify the local governments and the community members at least 60 days before submitting an application. And I think that would be, the very important for our county officials to be aware of, that an application, basically an applicant is intending to file an application within, I would say not exactly 60 days, but within that time frame. I'm honestly open to any or all suggestion, as like, given that overall the new process is very efficient when it comes to, there are, as I mentioned, some binding milestone and timelines in place by the statute that the office must comply with. I'm open to all suggestion, as like what would be, other than really, for those of you who know me, I'll make myself available within 24 hours if like I receive any question or comment from our local government officials. But other than just like keeping it, as I said, informally, and try to have an open line of communication and maintain this open line of communication moving forward. That's, I think, the first thing comes to my mind. But I'm open to any other ideas or suggestion as what's a maybe better way that we can, if you will, like formalize the interaction in a more systematic way, if you will.
Thank you. And Hutan's email address is also on the previous slide, Kate, if you could go back to that for folks to jot it down if you do have ideas and would like to connect with him. The next question is about the megawatt capacity of these facilities. It was mentioned that ORAS was for 25 megawatt facilities and higher, but are you aware of a proposal that might lower that to 10 megawatts?
That's, yeah, I mean, that was like as a part of the initial bill. I think they were the initial bill was contemplating a lower capacity. But no, the actual, like the law specifically talks about projects that there are over 25 megawatt and larger. However, projects between 20 to 25 megawatt, they can essentially opt into the new process if needed, or they can essentially proceed at the local level. So there is, if you will, an opt-in option, if you will, for 20 to 25 megawatt, but the definition of major renewable energy facilities, simply as I mentioned, for projects over 25 megawatt.
Another clarifying question, when you talk about local governments, both in terms of being consulted and being notified throughout this process, are you referring to towns, counties, cities, or both?
Yeah, I think it's within the boundary of the as we have defined in the regulations, within the boundary of the project. Yes.
Thank you. Next question, if a developer proposes a very large facility, for example, 200 megawatts, 1,500 acres, and the local government and community would strongly prefer something in the 50 megawatt, 400 acre size range, how can ORAS in the local government process play out?
So, I mean, that's, yeah, that I think that's an important question. That would be essentially would be part of the initial consultation with the applicant and with the office when it comes to deciding of the project. And certainly, I think I encourage folks on the call to take a look at the proposed regulations, like we have outlined the steps or the requirements that need to be discussed with our local agencies ahead of submitting an application. So this is like a topic that I think should certainly be discussed between the applicant and our respective local officials. And then certainly when we do require actual like transcript of like what has been presented in the discussion as a part of an application. And then if, again, like of course, like the applicants like will need to make a case why this project is important in view of the state's CLCPA targets and the environmental benefits of the project. Local governments will have an opportunity, as I mentioned, during the public comment period to raise any issue indicating whether, like, again, like this project should be proposed and the respective size of the project. That's something that it's just really hard to give you a generic answer. It is a really case by case, project by project. From my perspective, there must be a very strong reason behind why a certain system size cannot be developed in a host community, and that's essentially would be part of like the statement that, as we just discussed, like needs to be provided, and ultimately a judge will have to make a decision whether or not to grant that kind of waivers. From my perspective, it's really the emphasis should be as much as we can to work together early on and work with applicant as much as we can early on so we can address and avoid some of these issues down the road.
This question was directed to Kara, but I think we can answer it now. It asks, where can we find a link to the local government meeting tomorrow on the climate.ny.gov website? If you go to climate.ny.gov and you scroll about halfway down the page, there is a subsection for advisory panels. The first link there is for the Land Use and Local Government Advisory Panel meeting, which is tomorrow from 1 to 3 p.m. It is a GoToWebinar link. If you're unable to find it, please email me alamont, ALAMONTE @nisac.org, and I'm happy to send you the link. Another question for Hutan. Can you talk about the process NYSERDA is going through to proactively identify sites?
So I'm not necessarily very familiar with this. Can you hear me?
Yes, we
can you hear
can.
me?
Sorry about that.
Okay, good. Yeah, no problem. So yeah, I'm not necessarily too familiar with the NYSERDA process. So I would ask someone from NYSERDA, like if you don't mind, to reach out. As I said, NYSERDA will be an applicant under the new law to ORES, and if you will, like, we are creating firewalls that necessarily I don't want to be directly involved or engage with the NYSERDA process. So, but I would encourage you to reach out to someone from NYSERDA. If you don't have that, please reach out to me and I will be happy to make an introduction if needed.
Thank you. Before we wrap things up, we have just a couple minutes left. I want to give you the opportunity to expand upon Kara's answer to the question about avoiding a food versus energy conflict and land use conflict, particularly in relation to how we protect our prime soils and agricultural land.
So yeah, I mean, this is like one of the environmental issues that I personally take it very seriously. The New York State Constitution mandates that we shall protect our most productive farmland. So from our perspective, when we wanted, as much as we wanted to have a very robust clean energy industry in New York State, we would like to, if not more importantly, equally important, we would like to maintain and grow our agricultural industry. I have to tell you that I have been working very closely with my colleagues from Department of Ag and Market on the proposed set of regulations. The best way, or like the most precise way I can answer that is like, please take a look at our proposed application requirements. We created, and this is a kind of a new exhibit that did not exist under the previous siting law. We created a new exhibit for agricultural impacts, and also we have a set of specific conditions and requirement as much as we can to protect agricultural lands. But specifically from our perspective is we would like to, as much as we can, try to avoid those type of impacts that I think you're the person who's asking the question, we are, I think, probably raising. And if that's the first step, and then even beyond that, we would like to make sure, like in the next 20-25 years of the lifetime of this asset, we can preserve the farmland to the maximum extent practicable. So that's really the approach that we are taking, and we are taking it very, very seriously. So I encourage you to take a look at our proposed regulations and let me know if you have any questions. I would be happy to answer additional follow-up questions.
One final question we just received before we wrap things up. Does the permitting process address the end of life and dismantling requirements if the facility is abandoned?
Yes, it does. So we have one of our, like we have 25, the structure of a new siting process application includes 25 exhibits. As I mentioned, one of the exhibits is agricultural impacts, and the other one is decommissioning and restoration. So we do, we have a specific design criteria and requirement for applicants to provide and meet as a part of their application. Also, as one of the, I think, actually 2 or 3 conditions of the uniform standards conditions, specifically, we have requirements to for decommissioning for the applicant to work with local governments and try to essentially enter into an agreement to, at the end of the lifetime of the system, to decommission of the site and restore the site to the original condition to the maximum extent practicable. Again, I encourage you to take a look at the proposed regulations. We have specific exhibit for decommissioning and restoration and specific design criteria for what needs to be met and what needs to be provided. And then we have some requirement with respect to the uniform standards and conditions.
Thank you all for attending this virtual fall seminar workshop about meeting New York State's climate and renewable energy goals. Special thanks to our speakers, Hutan and Kara, for joining us this afternoon, and our sponsor, John W. Danforth Company, for sponsoring this session. You can find a recording of this webinar and a copy of the slide deck on our website at nisac.org/fall seminar. We hope to see you at our next virtual fall seminar workshop, which will be tomorrow at 10 a.m. The topic is governing through executive order. Thank you again for joining us. Take care.